All right, allow me to introduce myself. I'm Adrienne Stone. I'm the Director of the Centre for Comparative Constitutional Studies at Melbourne Law School, and I'm really delighted to be hosting this latest in our series of global public law seminars. This seminar on the topic of does Australia need a federal law on truth and political online at this time in evening to allow us to reach a global audience and a wider audience than we're able to do in our many other regular in-person events. So I'm delighted to welcome you all here today. And of course, I want to acknowledge that I am meeting with you from the traditional lands of the Wurundjeri people. The topic that we chose today arises out of recent developments in federal politics, which have seen a formal recommendation from the Interim Report on the conduct of the 2022 elections, a formal recommendation that the government develop legislation governing truth in political advertising. There has, of course, been a related development in 2023 with the Albanese Government releasing an exposure draft of a communications legislation amendment bill that addresses misinformation and disinformation. So this set of questions is very much part of our current politics and is there as an issue for law reform. It seemed an absolutely opportune moment to get together a group of experts to help us consider the question of whether Australia needs a truth in political advertising law, and if so, what such a law should look like. So allow me to introduce our speakers today. Excuse me. We will hear from three experts in order. The first will be Professor Andrea Carson, who is currently a visiting research fellow and has joined us from Oxford, where she's currently at the University of Oxford, working with the Reuters Institute for the Study of Journalism. Her home university and position as Professor of Political Communication at La Trobe University, and she is both a political scientist and a journalist who examines the news media's role in politics. We will also hear from David Mejia Canales, who is a senior lawyer at the Human Rights Law Centre, focusing on defending the rights of refugees and people seeking asylum and on promoting democratic freedoms. He has served in a range of other policy and community roles in related areas. And lastly, from Dr. Eliza Bechtold, also joining us from the United Kingdom, where she is a lecturer at the University of Aberdeen, although I'm delighted to say that we welcomed her to the Centre for Comparative Constitutional Studies for 3 months earlier this year, and it was conversations between me and Eliza that led to the seminar tonight. She researches in the area with freedom of expression, with a particular focus on disinformation and the regulation of online speech. We will hear from each of our speakers for about 15 minutes each, and then there will be time for a Q&A. If you would like to ask a question, please enter it in the Q&A function, and I will be able to put it to the speakers. All right, without anything further, I'd like to invite Andrea Carson.
Thank you very much for that very warm welcome, Professor Stone. It's a real pleasure to be here and with such a distinguished group of panelists. And may I also say another La Trobe alumni. So David, nice to see you on the panel as well. I've got a few slides here, and I'm approaching this question from a political science and journalism point of view, less so from a law point of view, which I'll leave up to the other experts that are on the panel. And I mean, when you pose the question of, do we want to stop politicians lying or political actors? Of course we do. I mean, it's a very seductive argument at its face value. But I think some of the things that we need to consider before we go down the path of legislation is what problem exactly is being addressed. We know that mis and disinformation is rife. It is a global problem, and it's a front of mind problem for governments around the globe, but less clear is exactly what impact it has on the ability for the public to make up their minds and to make the right choices for themselves at elections. I have done some work in this space, and I'll present some examples of that as we move forward. We do, fortunately, in Australia, do have some examples to go by. South Australia and the ACT, and South Australia has had that law in place for some time, with the commissioner responsible for looking at political advertising, truth in political advertising, and I'll touch on that in a moment. And I've done some work recently on the Voice to Parliament referendum in 2023. You can see from the slide that is the copy of a report that I, with colleagues, have put together, which really analysed the different types of political communication that was going on, the yes and the no campaigns, how they put forward their messages. And the report does contain a section on mis and disinformation and the role of fact-checking during the Voice to Parliament. And as I go through, I also want to look at other ways that this problem, this global ubiquitous problem of dis and misinformation, is being addressed. But before we do that, I think it's important to just quickly go through the definitions. One of the issues here is that there's always a continuum between free speech and between clamping down on these harms and having responsible speech, hopefully somewhere in the middle. Misinformation is usually viewed as false information that is spread, and disinformation is false information that is spread with demonstrated intent. It's very hard sometimes to divine someone's intention. So disinformation intent is usually operationalized through things such as super posting on chat boxes, using mechanisms where it is quite obvious that there's an intent to spread disinformation. As you can see in this graphic, the two overlap in terms of the fact that they can both cause harm. Disinformation almost always causes harm, and that can be in many forms. It can also cause benefit to those who are spreading it, whether that's financial benefit or political gain. Misinformation can also cause harm, even though it is the hapless spread or the unintended spread in many cases of false content. The reason I put these definitions up is because not everyone speaks from exactly the same position, whether it be journalists, practitioners, policymakers, and academics. And that's one of the challenges in addressing this problem, is bringing the definitions together. Across the globe, there's been 4 various ways that mis and disinformation has been approached. There's been co-regulation between platforms and media in a voluntary sense. This is what Australia has with its Code of Conduct for Mis and Disinformation. And as Professor Stone pointed out, there has been a draft bill trying to move that voluntary co-regulation into a mandatory space, which is following on from what from the European Union has with its Digital Services Act. And I would say that Europe is probably 5 years ahead of Australia. It also started off with a voluntary code and then moved that to a mandatory code, which provided a little bit more stick as well as carrot for the global platforms, Facebook, Google, X, and so forth, to take responsibility for the content that's on their platform. And then there's other legislative approaches. Some of these with the early adopters of anti-fake news laws, such as POFMA in Singapore, have often been adopted by countries that are probably classified as autocratic democracies or electoral democracies, or autocratic electorates. You can choose your label there, but those that have less political and civil freedoms than liberal democracies. And there's been some problems which I've produced a report in the past on, in Singapore and Indonesia, for example, where these laws are often used during elections to crack down on political dissidents and also on the media. And then the final way in which mis and disinformation is tackled by governments is supporting activities such as setting up fact-checking units, public education campaigns, media literacy campaigns, and so forth. When we look at definitions, it's also important to think about what is political advertising. And this is a broad range definition that means different things to different people in different jurisdictions. I've got the definition up there for the South Australian under its Act, Section 113. I think what's important to note is that political advertising does not, as we would think in layman's terms, necessarily mean paid for ads. It can be different forms of political communication. In the South Australian example, it is a statement purporting to be a statement of fact. So it's not about people expressing opinions. And in order for the commissioner to take action, it needs to be both inaccurate and misleading, and it must have a material effect on the election outcome or the potential to do so for the commissioner to make a ruling on it. The section I've got in yellow there is a comment that comes from the South Australian Electoral Commissioner in 2022 that one of the challenges that has arisen in relation to electoral advertisements is that it, particularly in the context of social media, is that the legislation does not provide a definition of advertisement, and differing dictionary definitions are being presented to argue whether material constitutes an ad. And in some of the examples where he has been charged with taking down information or asking for it to be retracted relates to political pamphlets and to Facebook posts. This legislation in South Australia has been in place for some time. It's been, I think, since 1997 that the Electoral Commissioner is solely charged with looking at misleading advertising. We can see, just comparing South Australia's 2018 election to 2022, that the number of complaints have gone up from 38 to 117 in the misleading advertising space. And in a correspondence with the Canadian Commissioner for their elections, the South Australian Commissioner wrote that it's usually politicians and political parties that are accusing each other of misleading political advertisements. And this was one of the fears where back in 1983, where Australia did flirt with federal truth in political advertising laws. In fact, it introduced legislation for 12 months and then repealed it in 1984. And one of the concerns there was that it would be gamed by politicians and it would slow down political communication, which is vital during a campaign so that the public can be informed and can get the necessary information that they need in order to make the right choices for them. However, of course, that was in an analog media environment. We're now in a digital media environment where information can circulate fast and wide, including mis and disinformation across the globe in literally seconds. And it makes it a much more high choice environment, and also one that has a low barrier entry for anyone with bad faith intentions. So turning to, as Professor Stone mentioned, the Joint Standing Committee on Electoral Matters, which was looking at, among other questions following the 2022 election, this question of whether Australia should be pursuing a truth in political advertising legislation at the federal level. Let's be clear, commissioners often do not want this. They do not want to be embroiled in arbitrating on political mis and disinformation. And that is quite separate from arbitrating on electoral mis and disinformation. So one is where disinformation is targeting the Electoral Commission or the process of the election and trying to tarnish its reputation or its role as a neutral administrator. Political disinformation is that which is spread for political gain, usually, and this is a comment that came out of those hearings from the current Commissioner, Tom Rogers, who said, good luck to whoever is the arbiter. It shouldn't be the AEC. That's our strong view, not because we don't want to, but because we don't think it's appropriate. It really could damage our standing as an independent, neutral, non-partisan organisation. And one thing I think that's really worth appreciating is Australian electoral management bodies, electoral commissions, also known as EMBs, do enjoy high public trust. Annual survey that is done of the public service shows that the Australian Electoral Commission is usually at the top of that list with about 90% trust. Follow-up reports from the South Australian election also showed similar levels of trust. Anything that might jeopardise that, of course, is going to make commissions nervous. But where are we in 2024? As mentioned, we're in a high-choice hybrid media landscape, meaning that people can get and do get their information from traditional media sources, from online sources, from paid sources and free sources. And of course, we now have the advent of generative AI, which I just learned being at Reuters. It's released its digital news report. And in that, on the section on Australia, it says that News Corp, for example, is producing over 3,000 stories a week using generative AI. So this is a very real space already across the globe, being a super year for elections, with about half of the world's adult population going to the polls at various points in 2024. Generative AI images have been used, and often they are used in very malicious ways to target female and women MPs and candidates. So this is a real problem that one will think as that technology improves will only get worse. It's important to have trust, as I mentioned, in EMBs, and we're also seeing another trend here where increasingly they are becoming the targets with accusations of stolen elections and rigged elections. The most prominent example was the Capitol Hill riots, where Donald Trump repeatedly said that the election was stolen. And we see a contagion effect across other parts of the globe, sadly, including in Australia, with accusations during the Voice to Parliament that the election was rigged and that it was in favour, was showing bias for the Yes case, which was something that Tom Rogers and others pushed back on, and rightly so. But what was unprecedented during the Voice to Parliament was that we had political leaders that were joining in with some of those accusations. In a radio interview, Peter Dutton, the opposition leader, said that we don't want a process that will be rigged, using that very inflammatory language that in a democracy is really very unhelpful when we need to have trust in our neutral electoral bodies. And again, this speaks to, if you change the laws in order to put the electoral authority as the arbiter of content that might be political disinformation, there's the real threat that those trust levels could be impacted. We have had other examples of disinformation campaigns in Australia. Many of you will remember the Mediscare campaign, a paper I did with colleagues on this, where we looked at it, did find that accusations that the coalition would dismantle Medicare if it got into power by the ALP. We found it did increase salience of healthcare issues during the election campaign, which suited the ALP very nicely because it is often seen as the custodians of health policy. The full article there can be found in the Journal of Elections, Public Opinion and Parties. Using a similar sort of playbook, the death tax appeared in 2019. This time it was the other side of politics that was accusing the Labor Party of introducing, if it came to power, an inheritance tax known as a death tax. One of the interesting things we found when we trawled through millions of Facebook posts and over 100,000 news stories in researching this was that misinformation can turn into disinformation, meaning that some people share this information thinking it's true. Other people do it maliciously in order to spread the falsehood. It can bounce between both of those, which is why definitions can be a little slippery, but also important. And the other thing is it bounces around between traditional media and social media. We found that the death tax narrative, false narrative, was able to have longevity for over a year because it would bounce from one medium to another. As soon as there was a campaign going on social media, it would be reported in mainstream media. And 53% of the time, the public was not disabused of the fact that this was not ALP policy. So there's a responsibility there, both for big tech, Facebook, and also for mainstream media to deal with mis and disinformation and to report information accurately. And then turning to the most recent electoral event that we've had, the Voice to Parliament referendum, the report that I've produced with colleagues, the one that I showcased on the first slide, we found many reasons for the success of the No campaign. Mis and disinformation were factors, but they were not the only factor, and that needs to be taken into account. If I can just look at some of the disinformation that occurred during the Voice to Parliament, it took different forms. Some of it was political disinformation that was trying to reshape the agenda of what the Voice to Parliament was about. Some of it was what we would call just fake news, masquerading, using the legitimacy of the layout of news to produce falsehoods, as you can see with that middle image. And then the final one, and the one that I was most interested in with an experiment we followed up with afterwards, was disinformation that targeted the Electoral Commission. With my colleagues, we ran an experiment shortly after the Voice to Parliament referendum to see whether that real-life disinformation, which came in various forms, including a meme saying that the Electoral Commission was supporting people voting more than once. We looked to see if those who were subjected to that disinformation, if it impacted their trust in the Electoral Commission. The short version is that it did. Those that only saw the disinformation without refutation or counter messaging did reduce their trust, which we found quite extraordinary, because usually it's the vanquished, not the victors, who complain about stolen elections. And in the Voice to Parliament, it was the No campaign that succeeded, and yet it was supporters of the No campaign that still had the view that the Electoral Commission that presided over that election was less trustworthy. Now, we don't know how long those effects last for, and it's a really important caveat for me to note that the AEC came off a very high trust base, and it was still high. The disinformation moved the needle a little, and it moved it more particularly in those that are from that don't support the major political parties and high consumers of Sky News. Just to put this in further perspective, when we trawled through 3 million Facebook posts and mainstream media stories, which is the top line here in red, we found there were 3 million stories and articles that related to the Voice to Parliament over the course of a year. How many contained accusations of the Electoral Commission being biased? About 5,000. So 5,000 out of 3 million, it gives you a sense of proportionality. But those that were about the Electoral Commission had a higher level of engagement, as you can see from the bottom line here, meaning that they were shared more on social media than the everyday stories about the Voice to Parliament. So I caution that we need to look at this problem in terms of its proportionality and the effects that it has, but also one where we should perhaps be alert but not alarmed. If we look again at the Voice to Parliament and what happened, an extraordinary result, 25% drop in public support over the course of a year, which is very large in any country by any standard. We can see that those largest drop-off points occurred when the political elites, the parties, decided not to support the Voice to Parliament. Firstly, the Nationals, as you can see there at the December 22 mark, and then when Peter Dutton announced that the Liberals would not be supporting the Voice to Parliament, you see that very steep drop-off in support from April through to September. this is important for us to note because we do know in political science that political elites provide really important cues to voters about how they should think about political questions and how they might vote. And here we can see that theory of political elite cues having an impact on the result. The types of mis and disinformation that circulate around, here's one real life example, and this is what we used in our experiment. This contains all the sort of motifs that we see from the US. There's the rigged election. There's also the UN globalist conspiracy theory. You might be able to see in the third line from the bottom. And then this idea that the AEC was condoning an idea of people voting often. Just to make it clear, the AEC was a neutral arbiter and certainly wasn't showing bias in any way and was not advocating for that position. So the big question, I think, for all of us is how concerned should we be about the spread of disinformation during elections, and particularly when it targets electoral management bodies, also electoral trust. We know from the literature how important electoral trust is. It goes to the very heart of political institutions' legitimacy and the confidence that we as publics have in election outcomes. Many studies have shown that disinformation can erode trust, and electoral management bodies around the globe are working and talking to each other about developing remedies of how to do this. Not all of them need to be down the line of legislation. Australia, for example, since 2019, has been publishing a disinformation register for anything that contravenes the Electoral Act and being able to show why that contravenes the Electoral Act. So we are in this contested space that ranges from some people suggesting that disinformation we're at crisis point, an epistemic crisis that makes it very difficult for people to be able to discern fact from fiction. And then at the other end of that spectrum is the idea that there's some moral panic going on here, and we need to have a more somber look at what actually is the challenge. As I just to come to the end of my remarks, as our experiment showed, we found that those that were exposed to that disinformation piece that I just showed you without any other form of refutation had lowered their trust, but that did come off a very high base and it was a small effect. And that provides opportunities to think about ways that counter messaging might work, and perhaps not with technocratic explanations, but using other mechanisms to do counter messaging, whether it's visual messaging or using humor or using things that don't directly go to outlining facts. And that's it from me. I'll stop sharing my slides and hand back to Professor Stone. Thank you.
Thank you so much. That got us off to a wonderful start. So, David, you're next.
Thank you. Thank you very much. And thank you very much for the invite to speak with you today. As mentioned by Professor Stone, my name is David Mejia Canales, and I'm a lawyer at the Human Rights Law Centre and in the Democratic Freedoms team in particular. So the things that kind of occupy us on a day-to-day making sure that the integrity of electoral processes are respected as is required by human rights law. So we're looking at the corrosive effects of mis and disinformation in particular, which is why I'm speaking to you today. Now, as was mentioned by Professor Carson, last year the government released its Combating Misinformation and Disinformation bill as an exposure draft. So it was effectively the government flagging its intention to regulate in this space and indeed the methods that it would take to do that. I think that there is at least a broad understanding of that this is a problem that requires some sort of intervention. And the bill was sort of made available to the public via the department. But I guess then something quite interesting happened with the kind of consultation processes, because it was the feedback that was received on this bill was absolutely incredible. And even speaking to the people of the department, and others, they were absolutely floored by how many submissions were received. So all in all, it was over 20,000 submissions, but most of those, 20,000 of them, in fact, were taken to be as correspondence, with 2,000 substantive submissions that were received by the department, which is an unbelievable number. It is an incredible number for any process, let alone something that was as dense and technical and finicky as combating mis and disinformation. But the reason why that happened is because the mis and disinformation bill was, in fact, indeed itself a victim of mis and disinformation. It actually became a bit of a kind of a culture war thing. There were members of parliament and indeed ex-members of parliament that ran campaigns, disinformation campaigns about what the bill would do, or indeed it was exaggerating some of the features of the bill that were really not intended, or at least did not do what these folks said that the bill did. So it actually became a culture war issue, which is why it received so many submissions, and most of those were accepted as correspondence, as mentioned before. So the bill had many problems, even though we do support, and I want to make that very clear, we absolutely do support intervention to limit mis and disinformation, not just because of its effects on our democratic processes and democratic speech and referendums and whatnot, but also in the effects of people and the effects on human rights more broadly, particularly as some communities do feel the impacts of mis and disinformation quite severely online. LGBTIQ plus communities, for example, communities of colour, and other folks that have been marginalised. But that's another conversation. So for the purposes of, I suppose, electoral speech and electoral kind of communication, there were many problems with the bill. The definitions of harm were quite vague, and also what sort of, the severity of that harm, that was also really poorly defined. So how severe does harm need to be for the bill to kick in? And also, I guess, for the purposes of our conversation today, there was some content that was excluded that was not going to be part of the regulations of the bill. And indeed, as Professor Carson mentioned before, it was setting up a voluntary process of codes that the industry would first be invited to form. And then if for whatever reason the industry didn't establish a code for regulating mis and disinformation, the regulator, the ACMA, could step in. And that's a very simplistic overview of how that would work. But I guess for the purposes of our conversation, some of the content that was excluded from the regulations was material that was authorized for election purposes. So you already start to see some of the difficulties here is that, so another exception was material that was produced for a professional news outlet or for educational institutions. So you could have a piece of disinformation or misinformation that would be covered if it wasn't said by a politician or if it wasn't authorized as part of electoral content, or that, if it was produced for a professional news source, even if that material could be, in other instances, considered mis and disinformation. So you had a situation where politicians could effectively, provided that the material was authorized, could spread mis and disinformation because that content was not covered by the codes. And indeed, ACMA couldn't register a code or determine a standard that contained requirements relating to electoral and referendum content unless they concern disinformation. And they do not relate to authorized content. So there was just all these gaps in the bill where the same bit of mis and disinformation could be treated very, very differently depending on who said it or who shared it. So that was, indeed a big problem in the bill, and many very, very learned people, including Professor Toomey, had some really excellent submissions about the deep problems with effectively politicians accepting themselves, if it was authorized electoral content, from the scheme of mis and disinformation. So We were expecting the bill to receive some sort of re-edit, overview, whatever the case may be, for it to be reintroduced by early this year. However, we tried in many, many instances to contact the minister's office to get an update on the bill. And also the general assessment was that this sort of legislation was either it needed too much work for it to be reintroduced, and that it was probably going to be quietly shelved until maybe after an election. That is until, of course, the terrorist incident that happened here in Sydney, as well as the stabbing incidents that happened in Bondi Westfield. And then I suppose the regulation for at least online harm gathered speed in a way that we were absolutely not expecting. Originally, the opposition was not in favour of the mis and disinformation bill because their arguments were that it would put the government as an arbiter of truth, that it would make government censorship, it would actually entrench government censorship over what people could see online. And in some ways, you could actually make that argument, but in many instances, you actually require a very, very long bow to get there. But you know, this is why the opposition kind of really opposed it, was quite negative on the bill until, of course, these incidents happened in Sydney. And then you had the opposition even flagging that some of the measures that were originally proposed in the bill were too weak or were not going to do enough to sort of solve the problem for online safety more broadly. But really, the conversations were not about, say, whether electoral speech should be protected and in what way, and how to prevent mis and disinformation from corroding electoral speech. A lot of the conversation was actually about how do we keep people safe online? How do we make sure that incidents of extreme violence are not amplified and platformed by these social media companies that indeed have a commercial imperative to share this kind of information across their platforms. So the conversation that we're kind of having now about the regulation for mis and disinformation is really about how to create safer online spaces. We have no idea what's going to be, when the bill is going to be reintroduced. However, the government has flagged, and indeed the Minister for Communications, who has carriage over the bill, has flagged that they are intending to at least introduce the legislation by the end of the year. So I guess what we are doing at the Human Rights Law Centre is that we think that civil society has a really important role to play in advocating for some really solid regulation to prevent mis and disinformation in electoral processes, but mis and disinformation online more broadly. So what we are doing at the moment is that we're putting some thought into, well, the initial, the flagged solution by the government had many, many holes in it. So I guess we are then just looking at what principles should underline really good regulation in this space, not just for electoral processes, which indeed they are really important for this purpose, but also, as I mentioned before, to prevent mis and disinformation online, the corrosive effects of misinformation and disinformation online more broadly. So we are in the process of developing some of those principles that we believe should guide regulation in this space. Indeed, one of them is to ensure that there is truth in political advertising. But it isn't just that. It is about kind of creating safer online spaces for everybody that also will protect communities of colour, LGBTIQ plus people from the corrosive effects of mis and disinformation. And that is the process that we're undertaking at the moment. We're consulting with tech experts, legal experts, and so on, to really get some of those really, I guess, the best case scenarios, or at least best practices from what happens overseas. Indeed, as was mentioned before, the Digital Services Act of the European Union provides a really good template and framework to how to mitigate for the really corrosive aspects of mis and disinformation online, particularly on electoral processes. But we're still waiting to see what the government is going to do. We do fear that as as these discussions sort of get underway and there is a bill introduced into Parliament, we do fear that this will kick up another kind of culture war aspect, and in many ways that's probably what is going to happen, and in many ways unavoidable because of what the laws are going to be regulating. But we do hope that at least we have some really clear examples, very recent clear examples, of how particularly online platforms are really benefiting from having divisive, reactionary, indeed mis and disinformation on their platforms, and how to actually tackle the problem from a risk-based perspective, as opposed to, say, chasing bad content all over the internet and pulling that down, because that is really just going to lock our government into an endless game of whack-a-mole that we will never, ever win. So with that, I'll leave it there and open the space for questions later. But I guess this conversation is not going to go away. It is going to increase speed. And it's really important for all of us to be really engaged and involved in the process, particularly lawyers and other professionals to really, I suppose, counterbalance some of those inflammatory claims that will absolutely be part of this conversation as the bill slowly makes its way into Parliament, at least by the end of the year. So thank you. Back to you, Professor Stone. Thank you very much.
Thank you so much. And now I'd like to invite Dr. Eliza Bechtold to speak. And just a reminder that at the conclusion, it will be possible for us to engage in some discussion and questions and answers, and you can use the question and answer function at the bottom of your screen to enter a question, and I will be able to put questions to the panelists. So, Eliza.
Thanks, Adrian. Claire, could you bring up my slides, please? So I think back in April, it was when Adrian and I started discussing a webinar, and here we are today, which was really wonderful. So thank you for helping or instigating this. So today I'm going to talk about recent developments and efforts to regulate political advertising outside of Australia. Over the next few years, around 3 billion people will be voting across the world. There are legitimate concerns, as have already been mentioned, that the increasing use of misinformation and disinformation in elections could seriously destabilize electoral systems, as well as the public's confidence in electoral integrity. And by extension, this could lead to political unrest, political violence, and potentially undermining newly elected governments. We've already seen this happen in the US in 2020, in the 2020 election with the big lie, which continues to pose a serious threat to American democracy, right? This lie about the integrity of the 2020 election, that in fact Biden did not win, and there was massive voter fraud instigated by Democrats, and that Trump is actually the true president. I think that's to a large extent why he was able to become the Republican nominee for 2024. So we see an effort in some jurisdictions to address some of the challenges with new legislation aimed at tackling the dangers posed by the spread of online misinformation and disinformation, specifically around elections, right? There's broader efforts because of the online harms, right, that are generated from this type of speech, but specifically we're seeing legislation aimed around elections and electoral processes. So because so many countries are facing similar challenges in this area, it can be instructive to be familiar with the regulatory efforts in other jurisdictions. As a comparative constitutional scholar, I'm a strong proponent of looking outside one's jurisdiction when thinking about these types of problems. I think there's a lot to be learned. So first, if you could switch to the second slide, please. Great, thank you. First, I'm going to discuss Ireland. So in 2022, Ireland passed the Electoral Reform Act 2022. This legislation contains a number of electoral reforms, including the establishment of an electoral commission, which is a new state body that is tasked with overseeing elections in the state. And the commission is also intended to regulate online political advertising per the act. So Part 4 of the Act concerns the regulation of online political advertising. It introduces new obligations on online platforms, which include flagging political advertisements and obtaining a statutory declaration from advertisers as to the accuracy of the information contained in the advertisement. It also requires platforms to have a button, hyperlink, or other connection connecting the user to the transparency notice. And requirements for the transparency notice include whether micro-targeting was applied in the placement, display, or promotion of the political ad, and the total amount that was paid for the ad. It also requires platforms to update the transparency notices in real time. Part 5 of the Act concerns the regulation of electoral process information, online electoral information, and manipulative or inauthentic behavior. It creates new obligations for platforms, including a requirement to notify the Electoral Commission of any disinformation, misinformation, or manipulative or inauthentic behavior. So you already have a lot of terms there published on the platforms that they're aware of, or they become aware of. It also requires online platforms to put user-friendly mechanisms in place, allowing users to report any such content that they believe they've come across. In terms of penalties, platforms that fail to comply with this requirement can be liable on summary conviction to a fine and/or up to 12 months imprisonment, or on indictment to an unlimited fine and/or up to 5 years of imprisonment. Additionally, any officer of a company that, through willful neglect or consent, allows an offense to occur can be prosecuted personally. So parts 4 and 5 were notified to the European Commission under an EU directive that sort of requires this sort of process in this area of regulation. And the process provides an opportunity for stakeholders and the European Commission to provide comments or observations on relevant proposals in a new law, in a new proposed law, and as standard practice. So there was nothing unusual about this process. Parts 4 and 5, though, having been notified in accordance with the EU directive, will require commencement order by the EU in order to come into operation and have legal effect. So this is where it gets a bit interesting. So the Commission found that aspects of parts 4 and 5 of the Act were incompatible with the e-commerce directive. So according to the Commission, in practical terms, in order to avoid criminal liability, online platforms would be required to determine whether the ad in question constitutes an advertisement prior to posting it. And according to the Commission, this and other obligations pose an onerous duty on platforms to systematically monitor the publication of political advertising. And this is in violation of the e-commerce directive, which prohibits member states from imposing a general obligation on intermediary service providers to monitor the information they transmit or store, or a general obligation to actively seek facts and circumstances concerning illegal activity. So the Irish government had to pause the implementation of parts 4 and 5, so other parts of the Act are in effect, pending further discussions with the Commission. And the Commission recently advised that it's still waiting to hear back from the government, the Irish government, on proposals to deal with the concerns over parts 4 and 5. So it's unclear whether those or when those provisions will come into force. Thank you. So in March of this year, and we see it's pretty recent, the EU adopted a new regulation on the transparency and targeting of political advertising aimed at countering information manipulation and foreign interference in elections. Most of its provisions are expected to start applying in autumn of 2025. So the aim of the regulation is to help people recognize political advertisements, understand who is behind them, and to be able to tell when they have received a targeted advertisement, right? So they're better placed to make informed voting decisions. The new rules cover the transparency and targeting of political advertising in relation to an election, referendum, or legislative process at the EU level or in a member state. They do not affect the content of political advertisements, nor other aspects of political advertising, such as the conduct of political campaigns, which remains subject to the national rules of member states. So per the new rules, political advertisements must be made with a transparency label and an easily retrievable transparency notice. and the label must clearly identify political advertisements as such and provide some key information, including the sponsor, the election or referendum to which they are linked, the amounts paid, and the use of targeting techniques. Also, targeting political advertising online will be permitted only under strict conditions. For example, special categories of personal data, such as data revealing racial or ethnic origin or political opinions, cannot be used for profiling. Also, to prevent foreign interference, there will be a ban on the provision of advertising services to third country sponsors 3 months before an election or referendum. So that's a high-level sketch of the new EU regulation, which is part of obviously a much broader effort to combat disinformation and misinformation online. All right, the next slide, please. Thank you. So finally, I just want to highlight some developments in the US. And I have to preface this, Adrian will not be surprised, that the use of disinformation in public discourse surrounding elections is a huge problem in the US. I mean, talk about an epistemic crisis, and I think that is an accurate label for what's happening. And in this election in particular, or this election cycle, we've seen the use of AI to, in an effort to improperly manipulate voters. One example is the New Hampshire Democratic primary. There was robocalls to potential voters that sounded like Joe Biden, discouraging them from voting. So that's just one of many examples, particularly about AI, but obviously the problem is much broader than that. In May of this year, the Senate Committee on Rules and Administration, with oversight of federal elections, advanced 3 bipartisan bills to address specifically the impact of AI on American elections. So we see a very narrow approach here. It's just looking to address the problem of AI. The bills include the Protect Elections from Deceptive AI Act, the AI Transparency in Elections Act, and Preparing Election Administrators for AI Act. So with respect to the Protect Elections from Deceptive AI Act, this is aimed specifically at deepfakes. It would prohibit the knowing distribution of materially deceptive AI-generated audio or visual media of a federal candidate by any person, political committee, or other entity for the purpose of soliciting funds or influencing an election. To enforce this prohibition, the legislation creates a new federal cause of action for any federal candidate whose voice or likeness appears in or who is the subject of materially deceptive AI-generated content. A good example of that would be the robocalls in the New Hampshire primary. Any actions brought under the act would be given scheduling preference under the U.S. Federal Rules of Civil Procedure, and federal candidates would be entitled to injunctive or equitable relief, prohibiting further distribution of the AI content, and they would be eligible for damages against those who distributed the content at issue. And they also get attorney's fees. Following clear and convincing evidence, that a violation occurred, there are notable exceptions here for parody, satire, and the use of AI-generated content in news broadcasts. So I just want to highlight there are some likely First Amendment issues with this legislation. Lies that fall short, say, of defamation, perjury, or fraud, generally get very high protection by the First Amendment, including those generated by AI. Anytime you're attempting to regulate political speech in the US, it's a very high burden to overcome First Amendment scrutiny. With respect to the AI Transparency in Elections Act, this would require disclaimers on political ads with images, audio, or video that are substantially generated by AI. The legislation requires political ads created or altered by AI to have a disclaimer, except when the AI is used only for sort of minor alterations, such as cropping, color editing, or other immaterial uses. Only advertisements that expressly advocate for or against the nomination of an election of a candidate, nomination or election of a candidate, or that solicit a contribution for certain political groups, candidates, political committees, would be required to label their content at all times. Advertisements that merely refer to a candidate, including those that include a voice or likeness of a candidate, would require a label during a window of 120 days prior to Election Day and including after Election Day. So this enforcement period apparently is designed to survive a First Amendment challenge, right, by narrowing the scope of its applicability. Now, that doesn't mean it would be successful. However, it would still be subjected to very intense First Amendment scrutiny. Finally, the Preparing Election Administrators for AI Act. This would require the Election Assistance Commission, which is an independent agency of the US government, in consultation with the National Institute of Standards and Technology, to issue guidelines that will help election administrators address AI's impact on election administration, cybersecurity, and election disinformation. So that's sort of just a high-level overview of sort of new regulatory proposals and laws relating to specifically disinformation, trying to tackle misinformation and disinformation in political advertising. Ireland's legislation, at least in this group, is the most aggressive of these efforts. It puts affirmative obligations on platforms, not only in terms of transparency, but effectively, well, according to the European Commission, right, requires platforms to monitor information on their sites. So it's more onerous than simple transparency obligations. The EU regulation is more restrained, tackling really just transparency, which is not surprising given the Commission's objections to or concerns with the Ireland or the Irish legislation, right, which the Commission thinks at least parts 4 and 5 violate the e-commerce directive. So regarding the US, I just want to mention that it's important to note these are just bills, and given the current composition and general dysfunction in the US Congress, I wouldn't think it likely that any of these would be enacted. Also, again, they're very narrow. They only cover AI. These types of regulations, really any type of regulation that's trying to regulate particular types of content, the Supreme Court, well, any courts pursuant to the Supreme Court will apply strict scrutiny to those, which is the most rigorous form of review. And because of that, it's unlikely that any sort of measures, again, specifically targeting particular types of content would be upheld. This is a problem that other jurisdictions don't have. There's not as significant of a hurdle just because the US has such expansive protections for political speech. And I think this is presenting a real problem in the US at the moment because there aren't a lot of tools available to sort of combat this problem in any meaningful way. And with that, I will end. Thank you.
Well, look, I better bring this to a close. You've brought us precisely to time. It's been for me really helpful to have these perspectives, interdisciplinary perspectives, practical perspectives, and international perspectives on this really, really difficult problem. There's lots more work to have done on it, but I know that I speak for everyone when I say we're just grateful for what you've been able to contribute today to this terrific discussion. So thank you very much.